Ms. Napolitano is number 22. Ms. Napolitano is recognized to explain her amendment.
Mr. Chairman, I have an amendment at the desk. Napolitano, number 22.
I'm sorry?
I have an amendment at the desk, sir.
Yes, you're recognized to explain your amendment.
Thank you, sir. I want to thank my colleagues, ranking members Norton and Congressman Nadler, for joining me in this offering of an amendment. The amendment strikes Section 611 from this bill, which would preempt states from setting meal and rest break laws to protect our truck drivers. On July 9th, 2014, the 9th U.S. Circuit Court of Appeals ruled that trucking operators in California must abide by California law and allow for a 30-minute meal break after 5 hours of work and a 10-minute rest break after 4 hours of work. This meal and rest break standard is very reasonable when you consider that truck drivers can be subject to 14 hours of on-duty time. Section 611 goes further than just overturning the federal court's decision, protecting California truck drivers. It would also preempt laws in 21 states and territories that guarantee meals and rest breaks. The states include Colorado, Connecticut, Delaware, Illinois, Kentucky, Maine, Massachusetts, Minnesota, Nebraska, Nevada, New Hampshire, New York, North Dakota, Oregon, Rhode Island, Tennessee, Vermont, Washington, West Virginia, Guam, and Puerto Rico. States should be allowed to set meal and rest break standards as they see fit for the health and safety of their own workers. This section has no place in the aviation bill, as this provision addresses motor carrier labor standards, which we had already debated in the FAST Act. The FAST Act Conference Committee wisely agreed that we should not interfere with state laws, and this provision was not included in the final FAST Act. Mr. Chairman, I ask unanimous consent to insert into the record letters opposing preemption of state meal and rest break laws for truck drivers from not only the owner-operated independent truck drivers, the state of California, Teamsters, and some other areas that have come to my attention. I urge my colleagues to support our amendment, and I yield back.
Without objection, those letters can be put into the record. As the gentlelady yields back, any other member wishes to speak?
Yes, Mr. Chairman.
Mr. DeFazio is recognized.
Mr. Chairman, as you know, this was rejected during the surface transportation bill consideration, did not get into the final legislation for good reason. It does preempt 21 states' regulations, wage and hour laws for intra-state trucking. Some of these laws date from the 30s. We're going to preempt those 21 states. By making it retroactive, we are going to save Walmart $100 million. Good on you. Because of pending litigation against them for violating wage and hour laws. And they are not the only one who would benefit. There's about 50 lawsuits pending. There's an issue I've raised for years. It's called detention time. It's also called by economists an external diseconomy. You are an independent truck driver. You got a load. You're going to my warehouse facility. Sorry, I don't want to put on another crew. That costs me money. You can sit in your truck for 5 hours before you can offload your load. Oh, you're going to be over the hours of service requirement and you got no place to park or rest? Sorry, you got to stay in line and you're going to wait 5 hours. We used to have rules that helped prevent that. It was called detention pay. Those rules are gone. But some states have figured out a way to get around that and stop those abuses and actually make the transportation system more efficient, the freight system more efficient, and not force truck drivers to violate hours of service rules just to keep up paying their mortgage payments on their truck. Now, that would preempt all those states that have figured a way to make those who accept the deliveries deal in a more reasonable way with those who have to make the deliveries and make a living. This preemption, now, there is a problem in California, and I offered a targeted fix. It's a one-state problem at this point in time, one state. And it has to do with a court decision which no one knows how to deal with, which seems to say that the state wage and hour laws apply to interstate trucking. So, and I've asked CalDOT, California Department, how are you going to do this now? Like, I'm driving a truck from the East Coast, I get to the Nevada border, I'm at this point on my federal clock, I hit your border, what clock am I on? How many hours? Does the clock just reset when I hit the border? Oh, we don't know. Yeah, we don't know. We don't know how we're going to do it. So California is a mess, and that needs to be fixed. I proposed a targeted fix that would, in a way, define interstate trucking and deal with this issue. But this, and although the authors of it purport it doesn't do this, this goes so far beyond fixing the California problem. It preempts those 21 states' wage and hour laws on intra-state trucking. Look at the list and see if your state is on there. And see if you want to deal with the angry independent truck drivers and others who can now be abused because your state's ways of, accommodating them reasonably have just been repealed by an act of the United States Congress. And talk to the Teamsters. We have now introduced an element. The bill is already weighted down with this privatization provision. Now we're going to weight it down with an unbelievably controversial preemption of 21 states' laws on wage and hour for trucking. I think it will be a huge mistake if this committee doesn't vote to remove this from the bill. And it will virtually guarantee this bill never, ever goes anywhere. With that, I yield back the balance of my time.
Mr. Denham is recognized.
Thank you, Mr. Chairman. And I rise in opposition of this amendment. I do agree with the gentleman from Oregon that this is a huge problem in California. It is a huge mess in California, but it is no longer just a California problem. The 94 law, the FAA bill, was very, very clear that this is an interstate issue that now not only is a California problem, but 20 other states have 20 other different laws. And as the gentleman said, there are over 50 different lawsuits already. If it hasn't come to your state, beware, because it will come to your state very, very soon by way of lawsuit. Look, the California law right now is unattainable. If you're a truck driver in California, you are breaking the law. In my production facilities, I have to provide a break room. I have to provide a break time. I have to allow them a certain amount of time and let them know exactly when their breaks are. But if you're a truck driver driving through California, are you going to pull over at an off-ramp and deter traffic when your time clock hits? Are you going to hope that maybe you're close to a rest stop and adjust your time clock then? It is unattainable in California, and I would argue that it's unattainable in the rest of the country. And I have continued to have conversations with the ranking member. We will continue to do that. But I would also take issue with that this was not handled under the previous bill. It was handled. This was a bipartisan vote. This did go through the House floor and should have been in the highway bill. Now we've got another opportunity to fix this in the FAA bill where it was originally handled in 1994. It was good then. It's good now. We need to resolve this issue, and I yield back.
And Mr. Nadler is recognized.
Yeah, we're always used to hearing rhetoric about states' rights. We're always used to hearing rhetoric about supporting workers. And here we're going to preempt the laws of 21 states, not on interstate commerce, but on intrastate commerce. That's what the Ninth Circuit held. We're talking about preempting the laws of 21 states on truck trips that begin in California and then in California. Begin in a different state, end in the same state. Number one, why is it our business? Number two, that state has determined, from my point of view properly, that they ought to have certain minimum wages and maximum hours for safety and for decency for truck drivers. And we're going to say no. This language dictates that whatever piece rate or pay by the load is determined by the trucking company is the only way that drivers can be compensated. State laws that ensure that drivers are paid a minimum wage, tracked by the hour, that they're paid for sick time or be paid for excess time spent detained at loading docks or at shippers' facilities or at ports will all be preempted. Why should we do that other than giving a gift for some of the larger trucking companies? We have candidates in both parties' primaries now all around this country exploiting a lot of anger that much of what we do here seems to be in the servants of very large companies who make very large or people who make large campaign contributions. Adoption of this amendment will give them more ammunition, more proof to say that. There is no reason for this. Let the states decide, and let's be decent to working people who drive trucks. I urge support of the amendment.
The gentleman yield.
I yield.
I agree with all the sentiments except that there's no reason. There is a contradictory court decision rendered in California, which I explained earlier, and that can benefit from a targeted fix, which I offered during the Surface Bill, which essentially adopts a definition of interstate versus intrastate trucking.
Reclaiming my time, I agree with the gentleman.
Okay.
But the fact that a problem exists that could be solved in one way is not an excuse for using that problem as an excuse to exploit workers, to preempt local laws, and to endanger the safety of the people who share the highways with the truckers.
If the gentleman further yield, I endorse that statement 100%. I just wanted to make clear that, that I think there's a problem we could solve.
There is a problem we can solve, but this amendment is not the way to, I'm sorry, this provision is not the way to solve it. This amendment ought to be adopted. I urge its adoption. I yield back.
Gentleman from Pennsylvania, Mr. Costello, is recognized.
Thank you, Mr. Chairman. Mr. Chairman, I urge my colleagues to oppose the Napolitano amendment to strike Section 611. In 1994, Congress, in a bipartisan manner, voted to preempt state laws relating to prices, routes, and services of motor carriers in order to promote an efficient, efficiency, innovation, and allow regional and national carriers to conduct business in a standard way. Motor carriers, including a constituent of mine whose case highlighted the Ninth Circuit's failure to follow Congress's directive, are now facing state laws establishing meal and rest break requirements that require the hiring of additional drivers and changes in routes and services. This is the type of patchwork which Congress intended to eliminate in 1994. Similarly, states are now enacting laws restricting the methods in which motor carriers can pay their drivers. These laws prevent motor carriers operating in multiple states or nationwide from conducting business in a standard way. In short, it increases costs and adds more confusion. Proponents of the amendment allowing courts to continue to curtail the intended scope of preemption, in this case for meal and rest breaks, argue it's necessary for safety. But that isn't true. The Federal Motor Carrier Safety Administration itself said that California's meal and rest break laws are not related to commercial motor vehicle safety. In fact, what I hear from drivers is that by forcing drivers to take additional, unwanted, and unnecessary breaks, the driver's day gets extended to maximum on-duty limits under the federal rules. That is not good for safety. Proponents also argue that the restrictions on the widely accepted use of piece rate pay in the trucking industry is necessary to protect drivers and make sure they earn at least the minimum wage. When you talk to drivers, you understand that piece rate pay allows them the opportunity to make considerably more money. The laws that Section 611 would clarify are preempted, do nothing to put extra money in a truck driver's pocket. They simply require carriers to allocate the money in a different manner, requiring significant changes to payroll systems. Section 611 is necessary to restore uniformity to regulation of the interstate trucking industry. It is an interstate trucking industry. It does not leave the industry unregulated on breaks or minimum wage, but it does provide consistency to how the industry is regulated. I respectfully urge my colleagues to vote against this amendment. I yield back.
Any other members wish to be heard? Ms. Brown.
Thank you, Mr. Chairman. If it's one thing I hate, and I love this committee, but I hate to have to disagree with my friends on this issue. But this same language was included in Section 611 of this bill, was included in the House Surface Transportation Bill through the passing of a bipartisan amendment on the floor, but was removed in conference by the Senate. This issue and this language and this amendment was addressed in the original bill in 1994 and really has been enacted for over 20 years until a court in California imposed this additional language. The bill does not alter or roll back any hours of service regulation that currently govern drivers, and it doesn't prevent drivers from taking meals or rest breaks. It simply allows the professional truck drivers the flexibility to take rest breaks when they think it's appropriate, not when the state of California think they should. As freight transportation continues to grow in the foreseeable future, it is vital that we not burden truck drivers and the companies they work for with the challenge of 50 different state regulations governing their business. Let's reinstate Congress' initial intent and let these businesses get back to work, delivering the goods and services to our citizens. I hope that the young lady, my friends, will withdraw this and that we will work to come up with a language that's acceptable in a bipartisan manner. Now, we have some disagreements on this issue, but I am hoping that we can work this out before this bill gets to the floor. And with that, Mr. Chairman, I yield back the balance of my time.
Thank the gentlelady. Mr. Ribble.
Yes, thank you, Mr. Chairman. I rise in opposition to the amendment. And the reason being is there's been a lot of discussion today about the states' rights as it relates to this issue. Listen, I'm a big states' rights guy. I would much prefer that the federal government doesn't do much and states do more. However, under the 10th Amendment of the Constitution, those states' rights are reserved for things that were not enumerated. So if it's not enumerated in the Constitution, it was left to the states. However, this is an enumerated power. The regulation of commerce was decided by the original 13 states to be left to the federal government. Now, whether you agree with this particular amendment or disagree, the constitutional argument is it is our responsibility to decide. And so there's not a states' rights issue here. This is the Article 1, the Constitution gives the Congress of the United States the power to regulate interstate commerce. We can't have a potpourri of regulations all around the country, which would completely make the U.S. movement of goods and services so uncompetitive that you couldn't function. The founders of our nation knew that. They understood that. And so they agreed together and said, we're going to, together as a collection of states, agree that we're going to allow interstate commerce. We're going to control it at one spot, not at 13 or now today at 50. And so it is our responsibility to make this decision, and I would recommend that we vote in opposition to this amendment for that reason. And with that, I yield back.
Thank you, Mr. Ribble. With that, recognize Ms. Norton.
I was pleased to co-sponsor this amendment with my friend, Ms. Napolitano. Actually, I was surprised that when you have a situation where almost half the states are involved and felt they had to chime in the same way, that we're having this kind of discussion. And I'm sorry that the ranking member's fix didn't come and prevent us from having to have this discussion at all. Remember, we haven't had any hearing on this, so we really are in the dark about why 21 states, that's a large number of states, have felt that they had to be heard on this. I just want to read something from the California decision. And the California decision involved, and that's why I think a fix might have helped this, involved, of course, commerce exclusively within the state. And the court said the requirement that a driver briefly pull off the road during the course of travel does not meaningfully interfere with a motor carrier's ability to select its starting points, destinations, and routes. Starting points, destinations, and routes, of course, go to interstate commerce, not to rest and meal breaks. And may I remind the committee that we've just passed the new Surface Transportation Bill, the FAST Act, which had something analogous in it, which all agreed to. And that is a study. We found that inner-city bus drivers and transit drivers could not take a rest break. And what we required in the FAST Act is that there be a study by the FAA, followed by a rule after we found that there were serious health consequences like irritable bowel syndrome and some that I don't think I should have to mention that occurred when there was no rest break whatsoever. I don't see why the respect due to these almost half the states of the union should not be given by this committee, and I reserve the balance of my time. I yield to the ranking member.
I thank gentlelady. There's some misunderstanding here. Yes, there is a confusing court decision in California, but the confusion is the disconnect between intrastate and interstate trucking, and also the issue of what Congress intended to preempt. And even though part of their decision is wrong and we could fix that in a targeted way, it's being used as an excuse to go out and preempt a whole bunch of other states that aren't even in the California circuit, so none of the ruling applies to them, but they're going to be preempted. And what some of these states have done, and I referenced it earlier, is they've found, they have said wages, you have to pay hourly wages. The trucking industry would love to pay piece rate. So you're getting paid by the load. Some parts of the trucking industry, not parts that I work regularly with, but some would like to do this. So you got the load, you get to the warehouse, and you wait for 6 hours, and oh, now you violated hours of service, and blah, blah, blah. You get paid for the load. It can turn out to like, $1 an hour. Sorry, you don't get paid by the hour, you get paid by the load. And if there's an inefficiency, well, that's beyond our control. We're the people who just put the load on your truck. We don't control the warehouse where you're delivering it. So California, this was an intrastate issue that the court screwed up. It was people delivering air conditioners within the state of California. And the court just added something that created this problem with interstate trucking, which we could fix easily. So, what California was trying to fix is people who are basically working for free by getting there, sitting and waiting to load or unload. And making that they would get hourly wages while they're sitting or waiting. And the court did say, although we have in the past, as related to Mr. Ribble's comments, we have in the past confronted close cases that have required us to struggle with related to test and refine our principles of FAAA preemption. I guess there's only 4. We do not think that this is one of them. In light of the F4A preemption principles outlined above, California's meal and rest break laws plainly are not the sorts of laws related to prices, routes, or services that Congress intended to preempt in an earlier FAA bill. So, that interpretation was incorrect. With that, I yield back the balance.
Undermining congressional intent. As was stated earlier, in 1994, in a Democratic-controlled House, it was passed on a bipartisan basis to make it clear. And as Mr. Nadler was saying, why do we get involved? Because this is an interstate commerce issue. It's an interstate commerce issue, and we have federal rules on the books dealing with interstate commerce, and California is doing things that are disrupting that. And Mr. DeFazio, or no, excuse me, not Mr. DeFazio, Mr. Nadler also made a comment about these big industries that support interest. Well, let me tell you who this supports. It's the trial lawyers. The trial lawyers are one of the largest contributors to the other side of any contributor. This is a boon for them. There are trucking companies that are based in California that have already paid out $50 and $60 million, and let me tell you, the truck drivers there's out there saying they're defending are probably not getting much of that benefit. These are going to big law firms that are taking these cases. We have trucking companies that are leaving California and already have left, or deciding they're not going to go to California because of this. This is an interstate commerce issue. This is an issue that, as Mr. Ribble pointed out, constitutionally, this is our duty to make sure that we do this. And as I said, we already have federal regulations on the book when it comes to duty on truck driving. And it also is important, not just the trucking industry, the railroad industry, the airline industry, people that go across these state lines to make sure there's not a patchwork of state laws and regulations that disrupt and undermine the efficiency of the interstate commerce. So again, and as was also mentioned, this was passed on the floor with a bipartisan vote. Unfortunately, it didn't make it to the end, but here we are today again debating this, which I think is the right thing to do. I oppose Ms. Napolitano's amendment and look forward, if any other member wishes to speak, we'll go to the vote. Mr.
Yeah, Mr. Chairman, real quickly, this is not how the real world works. This patchwork of laws is creating lawsuit after lawsuit for the trucking industry and the delivery of goods in America. I think we have to remember the only thing that's not delivered by a truck in America is a baby. So I recommend a no.
Any other members wish to be heard? Is there an amendment to the amendment? Mr. Lobiano.
Well, as one of the members, and I think we have a new member of the committee who's actually helped run a family trucking business, you need standardized rules and regulations. You can't operate in a patchwork. It just does not work if you don't have standardized rules and regulations. And as has been said by some of my colleagues, this helps you give the standardized rules and regulations without which it's just impossible to operate.
Yield back. With that, any amendment to the amendment? Seeing none, all those in favor of Ms. Napolitano's amendment say aye. Aye. All those opposed say no. No. According to the chair, the noes have it. The amendment's not agreed to. Mr. DeFazio.